You've just been involved in a very serious incident and you had to use a gun to defend yourself. What do you do next? That's the subject of today's Need to Know. Need to know what? Need to know the law. Dave McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one of the same. This is part 4 of our series on self-defense. So let's get right on into it, okay? You just had to use your gun to defend yourself. What do you do now? Hopefully you have a self-defense plan, as we discussed before, which means you've already got certain people that you intend to contact in the unlikely event that this takes place, such as USCCA if it's a potential carrier, your attorney, a family member, whoever the situation might be. You want to avoid having to call 911 yourself directly, and I'll tell you why. In most situations, when you call 911, they're going to ask you a series of different questions. You're going to be answering these different questions on a recorded line, okay? That's information that can be used, that's evidence rather, that can be used against you during the course of your trial. If you say anything that's potentially damaging to your case, that's not a good thing, obviously. So you want somebody else to be calling on your behalf. Very often when other people are around, they're going to call anyway. Number 2, you want to stay there. You want to stay put if possible. If the situation is not safe, if you cannot stay where you're at, get out of there, and you're going to have to immediately contact your attorney with respect to what you should be doing next as far as how you're going to contact the police. Number 3, when the police come, very often they're aware that a very serious incident just took place and that there was a shooting involved, if in fact there was a shooting involved. So they're going to come there not exactly knowing the facts of the case. They're not going to know who you are in relation to what actually just occurred. They're not going to know whether you're defending yourself. They're not going to know what happened. So if they see a gun, obviously that's very threatening for a police officer, for anybody. They're going to want to defuse that as quickly as possible. You really want to have it so there's no gun in your hands at the point that they show up, okay? That your hands are completely available to them so they can see it, so that you do not pose any threat to a police officer or anybody else that's around there. Again, there's certain circumstances where you can't do this because you're still not in a safe environment. But to the extent you can, make sure that you present yourself in a very safe manner. Number 4, the police are going to ask you questions about what occurred. This is the point where it doesn't make any sense to say anything, okay? There's a Miranda decision. You've heard of your Miranda warnings. It's a case, a 1966 case, I believe, out of Arizona, Miranda v. Arizona, where they discuss the significance, constitutional rights of an individual that's being arrested, okay? So once somebody's been arrested, they're in a position where they're not free to leave. The police have them. They're not free to leave. Very arguably, that constitutes an arrest as well, whether they've been formally put under arrest. But once they're in a particular position where they've been arrested, the police have to warn that person, you, if in fact you're involved in this particular incident, that you have a right to remain silent, that anything you say can and will be used against you in court, that you have a right to an attorney. If you cannot afford one will be provided for you free of charge, okay? Those are your rights with respect to Miranda, with respect to that case. They are required to tell you that. What's the significance of this? A, heed that warning. Understand that warning. You don't have any right you don't have any obligation to speak, so don't speak. Very often, whatever you say, even if you're saying, hey, look, I was involved in a very serious situation. This guy just attacked me. I was scared to death. I shot in fear of my life. Very often, anything you're saying is going to be recorded, okay? If it's not recorded by a body-worn camera or a squad camera or a in-station camera, it's very often going to be written down, and it might also be written down as well, even if it is recorded by the police. So a police officer, whoever you're telling the story to, imagine if you tell the same exact story to 3 different people. Very often, you tell the same exact story to 3 different people, depending on how long that story is. Those 3 different people are going to leave with 3 different versions of what they understand to have taken place. So it's the same thing here. So later on in the case, if you've made a statement during discovery, which is the exchanging of any information, any documentation, any evidence that's going to be used during the course of the trial between the state and the defense in a felony case, very often that information is going to be there. In a police report, there's going to be a description of what you said, and that description can be used against you. And you might read what the police officer is saying you said and say, hey, that's not true at all. And you know what? It is possible that a police officer is just lying about it. But in all probability, if you're saying something that a police officer wrote down, since they don't have any stake in this, they don't have any interest, there's no real reason for them to just lie or invent something. In all probability, what you're reading is exactly what they interpreted from what you told them. So you kind of put yourself in that situation by speaking to the police officer. Another thing is, if you're saying that you had to defend yourself, very often you might perceive what you just did as self-defense, but your attorney might not perceive it as self-defense. So now you've just limited the theory of the case. In other words, we have to go from, hey, prove him guilty beyond a reasonable doubt, to, okay, you already know that he shot somebody because he already admitted it. So it narrows the defense and what you can and can't argue with respect to your case. So you don't want to say anything for that reason as well. People often go ahead and make statements to the police prior to being arrested. Most of the time, many of these statements come into evidence during the course of a trial. you weren't already arrested. So they're asking you questions just to kind of investigate the situation, just to kind of do their due diligence to find out what happened. You're providing them with information. You feel like, hey, you haven't been placed under arrest. Everything's good. If you subsequently are charged, you've now just provided various different statements that can be used against you during the course of the case. So very often, it's just very important to know not to say anything. Contact your attorney or a family member that you've already discussed you've had discussions with respect to, hey, if this happens, I'm going to call you, this is what I need you to do, or the plan that you already have with respect to a different entity that might be reaching out for representation on your behalf, whoever that entity might be. Have all these different things in place. In the very unfortunate event that you have to use your gun to defend yourself, it's going to be invaluable that you're doing this. Hopefully this is very good information for you. Either way, stay safe. Hopefully you're never put in a situation like this. Talk to you soon.